Let us take a look at Joey's family. So in Joey's family we have Joey, his elder brother, his mother and his father. Joey's father is responsible for calculating the finances of the family. So what money comes in and what money is spent, Joey's father takes decisions regarding that. Joey's father also cleans the house. So decisions regarding the hygiene and cleanliness of the house is also taken by Joey's father. Joey's mother is also responsible for calculating the finances of the house. So Joey's mother also takes decision regarding the money that is spent by the family. Joey's mother is also responsible for tutoring Joey. Joey's brother has a passion for cooking. So Joey's brother takes decisions regarding what meals are being cooked for the family. And Joey is still quite young and does not have much of a real responsibility. So as we can see in Joey's family, his parents and his brother have different responsibilities. They have the power to take decision regarding different matters. So this can be loosely termed as jurisdiction. So Joey's mother has jurisdiction over tutoring him and over the finances of the house, while Joey's father has jurisdiction over the finances of the house and the cleanliness. And Joey's brother has jurisdiction over the meals that are being cooked. And as we can see, Joey's mother and father both are maintaining the finances of the house. So they have a shared jurisdiction. In this video, we will be talking about what jurisdiction means and the jurisdictions of the high courts of the country. So in law, jurisdiction means the power or authority that has been given to the courts of law to take decisions regarding matters concerning the law. The word jurisdiction comes from juris, which is a Latin word which means law, and dicere, which is also a Latin word which means to speak. So jurisdiction means to speak the law or to tell the law. So jurisdiction is the power or the authority given to the court to interpret the laws, pass judgments and resolve disputes by taking decisions in the matters concerning the law. The High Courts of India have been given several jurisdictions. So the High Court has original jurisdiction, appellate jurisdiction and revisory jurisdiction. In this video, we will be looking at each of these individual types of jurisdiction. So original jurisdiction means the cases that can be taken up by the High Court directly. So cases which can be initiated, discussed and decided on by the High Court in the first instance. So in these cases, the cases do not have to be coming from a lower or a subordinate court. So the original jurisdiction of the High Court extends to the cases in which the High Court has the authority to hear and decide in the first instance. So before India got its independence in 1947, there were already several High Courts that were functioning in different parts of the country under the British Raj. So these courts used to have the appellate jurisdiction. They used to take appeals from the lower courts or the subordinate courts. So the constitution makers did not give a clear cut or well defined original jurisdiction to the High Courts. But let us take a look at what all matters fall under the original jurisdiction of the High Court. So India is the largest democracy in the world. There are a lot of direct elections that take place in the country. The election of the members of the Lok Sabha and the members of the state legislative assemblies are taken up through direct elections. So in these direct elections, there is a lot of citizens who come together and vote. Since this process involves a lot of people, the process invests a lot of manpower, time and money. And because the procedure is so extensive, a lot of problems and disputes are bound to arise, isn't it? So that is why when there is a problem regarding the elections, that go to the High Court. For example, if a person has filed his nomination papers for election in the state legislative assembly, and the returning officer looks into his papers and rejects it. But the person feels that there is a discrepancy, so then he can move the High Court. He can ask the High Court to look into the matter and include his name in the list of valid nominations to the election. So we see that whenever there is a problem regarding the election or election disputes, these disputes go to the High Court. So election petitions can be heard and decided directly at the High Courts. The High Courts are also known as the interpreters of the Constitution, which means that the High Courts can interpret the Constitution and apply the Constitution's provisions to the different cases that come to it. So the High Courts have the power of judicial review and can take up constitutional cases in which interpreting the Constitution is involved. So judicial review is the power of the High Courts to review any law that has been passed by the legislature or any action that has been passed by the executive, and to decide whether it is in conformity with the provisions of the Constitution. So if the High Court feels that this law or this action goes against the spirit of the Constitution, then it can strike it out and declare it null and void. Now we also know that the Constitution has given us several fundamental rights, but simply giving these fundamental rights is not enough. These fundamental rights have to be protected and guaranteed. So the Constitution empowers the High Courts and the Supreme Court to issue writs to enforce the fundamental rights. So the High Courts can issue writs for the enforcement of fundamental rights. To know more about what writs are and which writs can be issued by the High Courts, you can click on the link to access the iDictionary feature. Now imagine that you have a friend named Neha, whose parents are separating after certain years of marriage. They have filed for divorce. Now after this, the custody of the children and the alimony will have to be discussed. In this case, the matter can go to the High Courts. So matters such as marriage and divorce fall under the original jurisdiction of the High Courts. Other than this, High Courts can take up cases regarding revenue, wills, admiralty, that is cases concerning the sea and the ships, company law, etc. directly. So all of these fall under the original jurisdiction of the High Courts. Now as we had already seen, there were several High Courts which were already functioning in the country before the independence. So these courts at that time had original jurisdiction in civil and criminal matters. But after independence, these High Courts lost their original jurisdiction in criminal matters but held on to their original jurisdiction in civil cases of higher monetary value. So the High Courts of Delhi, Bombay, Calcutta and Madras have original jurisdiction in civil cases of higher monetary value. Now let us take a look at the appellate jurisdiction of the High Court. So when a case is going to a lower court or a subordinate court, and after the judgment has been passed, if either or both of the parties to the dispute feel that the judgment that has been passed is unjust, then there is a scope for appealing to a higher court. For example, a person or a party to the dispute feels that the judgment has been unjust because he has not been represented properly by his lawyer, or because he feels that the judge has not taken into consideration all sides of the argument, or if a new fact has come up in the case. Then in such a situation, the person can appeal to a higher court. Appellate jurisdiction, the word appellate comes from the word appeal, which means to make a heartfelt, a serious or an urgent request. So in this case, a person whose case is there in a lower court can appeal to a higher court. And if the High Court feels that the case is a genuine one, then it can look into the case. And if it feels that the judgment which has been passed is unjust, It can strike out the judgment and look into the matter itself. So the power of the high courts to review the rulings made by a lower court and to potentially change the outcomes of a lower court's decision is known as appellate jurisdiction of the high courts. So we know that the high court is the highest judicial authority in a state, but there are several other courts in the states and the districts which fall under the high courts. So in civil courts, we have courts such as the district court, the sub-judge family and the municipal courts. And under criminal courts, there are session courts, the chief judicial magistrate first class and judicial magistrate second class. So appeals against the judgments of the subordinate courts lie to the high courts. So the high courts can take up appeals against the judgments made by the subordinate courts in two types of cases. That is civil case. That is civil cases and criminal cases. Let us see which criminal cases. Now let us see in which types of civil or criminal cases appeals can lie to the high court. So can you answer this question? The high court hears appeals against which court? Is it the Supreme Court, High Court of a different state, subordinate courts or municipal courts? Yes, the correct answer is subordinate courts. Now let us talk about in which civil cases the High Court can take up appeals. So we know that like the High Court is the highest judicial authority in a state, the district court or the court of the district judge is the highest civil court in a district. So the appeals from the judgments of the district court lie to the High Court. So the High Court hears appeals against the decision of the district judges and the additional district judges. So appeals against the judgments that are passed by the district judge and the additional district judges who sit at the district court are heard by the high courts. Other than this, the High Court hears appeals in matters of land revenue and from orders of tribunals. So what are tribunals? Tribunals are special boards that are set up by the government to deal with several types of cases, such as cases concerning the environment, employment, taxes, labor law, etc. The functioning of the tribunals is not exactly the same as the courts of law. The procedure is less formal than that of the law courts of the country. There are various tribunals in India, such as the Central Administrative Tribunal or the National Company Law Tribunal, which have been set up to reduce the workload of the courts of law. So if a judgment has been passed by a tribunal and the judgment does not seem to be fair, then appeals against the judgments of the tribunals can also lie with the High Court. Now let us see in which criminal cases the High Court can take up appeals. We know that the highest criminal court in a district is that of the Sessions Judge. The court of the Sessions Judge, in which there is the Sessions Judge and the Additional Sessions Judge. The Sessions Judge and the Additional Sessions Judge have the power to give death sentences or life imprisonment. But if they have given a punishment for over 7 years of imprisonment, then an appeal can lie to the High Court. So the High Court hears appeals against the judgment of a Sessions Judge or Additional Sessions Judge when the punishment exceeds imprisonment of 7 years. Now there are several other criminal courts that lie below the court of the Sessions Judge. In those criminal courts, there is the power to give a punishment of maximum 7 years. So in that case, the High Court hears appeals against the judgment of an Assistant Sessions Judge, Chief Metropolitan Judge, or the other judicial magistrates when the punishment exceeds imprisonment of 4 years. Other than this, if the Sessions Court gives death sentence as punishment, then the case automatically goes to the High Court for review. Since death sentence can be given in the rarest of the rare cases, therefore all decisions to give a death sentence have to be reviewed by the High Court. Now let us imagine a case in which Mr. Ahuja has a property with a valuation of 20 lakhs. After his death, it is found out that Mr. Ahuja has left no will or no deed as to who shall get that property after his death. Mr. Ahuja has 2 sons and 1 daughter, and these siblings are having a lot of disagreements among themselves as to what part of the property each of them should get. So these people go up to the nearest Munsif court. Now let us assume that this Munsif court has the power to take up a case with a value of less than say 1000 rupees. But the Munsif court takes up this case and looks over it and gives a judgment. It says that the sons should divide the property among themselves as half and half, and the daughter is entitled to the property. Now the High Court sees this case and realizes that the Munsif court has given a judgment in a case which did not fall under its jurisdiction. In such a case, what would the High Court do? Does the High Court have anything to do here? Well, it does. The High Court has a power which is known as the revisory jurisdiction. In this power, the High Court can take up a case from a subordinate or lower court if it feels that the judgment is not proper, or if the court has exceeded the jurisdiction that is actually given to it. So in this case, the High Court will take up the case itself and look over it. And if its decision is not the same as that of the Munsif court, then it can quash the decision given by the Munsif court. This power is known as the revisory jurisdiction of the High Court. The High Courts of the country have the responsibility to look over the subordinate courts that lie under its territorial jurisdiction. So, the High Court is empowered to call for the records of any case which has been decided by a subordinate court. This is done to ensure that if the subordinate courts have given a judgment which is unjust, or if it has given a judgment on some matter that is not under its jurisdiction, then such mistakes in the case are not allowed to continue. That makes up the revisory jurisdiction of the High Court. The cases are known as transferred cases and the power is known as the revisory jurisdiction. Now in this video, we've looked at the types of jurisdiction that the High Courts of India have. The High Courts of India have original, appellate and revisory jurisdiction. So original jurisdiction of the High Court is the cases in which the High Court has the authority to hear and decide in the first instance. Appellate jurisdiction is the power of the High Courts to review the rulings made by a lower court and potentially change the outcome of the lower court's decision. While revisory jurisdiction is the power of the High Court to call for the records of any case which has been decided by a subordinate court. So, these are the jurisdictions of the High Court. In our next video, we will look at the functions of the High Court, in which we will see how the High Court carries out its jurisdictions efficiently. Don't forget to subscribe to our channel and hit the bell icon. You can also register for free at DeltaStep.com or download the DeltaStep app to get access to all our 5,000 plus amazing videos as per your school syllabus. Master each topic with our adaptive practice technology. Get million+ questions with step-by-step solutions and unlimited mock tests. Get all your doubts resolved instantly. Learn via games and win amazing prizes like PlayStations and iPads. So at DeltaStep, learning is not just fun and easy, it is rewarding too. So register for free now.